Hello, I am Leela and I am pursuing BA Honours in Political Science from University of Delhi. So today I would like to discuss about the silent feature of the Constitution of India. Constitution is the rule or law that guides how state or country work. The Indian Constitution is very unique in its content and spirit, though it is borrowed from almost every constitution of the world. The Constitution of India has several silent features that distinguish it from the constitution of other countries. So the first feature of the Constitution is the lengthiest written constitution. The constitutions are classified into written like the American Constitution and the unwritten like the British Constitution. The Constitution of India is lengthiest as well as written constitution of the world. It is very comprehensive, elaborate and detailed document. It took 2 years, 11th month and 18 days. It contains 448 articles divided into 25 parts and 12 schedules. Originally, the constitution contained a preamble, 395 articles divided into 22 parts and 8 schedules. The various amendments carried out since 1951 have deleted about 20 articles and one part is 7th and added about 90 articles, 4 parts, 4th A, 9th A, 9th B and 14A and 4 schedule 9, 10, 11 and 12. No other constitution in the world has so many articles and schedules. 4 factors have contributed to the elephantine size of the consistence of constitution. The first is geographical factor, that is the vastness of the country and its diversity. Second is the historical factors in the influence of the Government of India Act 1935, which was bulky. And the third is single constitutions for both the central level and the state level. Fourth is dominance of legal luminaries in the constitute assemblies. The constitutions contain not only the fundamental principle of the government but also a detailed administrative provisions. And the second feature of the constitution is drawn from various sources. The constitution has borrowed most of its provision from the constitution of various other countries as well as from the Government of India Act 1935. Dr. B.R. Ambedkar proudly acclaimed that the Constitution of India has been framed after ransacking all the non-constitutions of the world. The structural part of the Constitution is to a large extent derived from the Government of India Act 1935. The philosophical part of the Constitution, like the fundamental rights and the directive principle of the state policy, derive their inspiration from the American and Irish Constitution respectively. The political part of the Constitution, like the principle of cabinet government and the relations between the executive and the legislatures, have been largely drawn from the British Constitution. The other provisions of the constitutions have been drawn from the countries of Canada, Australia, Germany, Russia, France, South Africa, Japan, and so on. The most profound influence and the material source of the Constitution is the Government of India Act 1935. The federal scheme, judiciary, governance, emergency powers, the public service commissions, and the most of the administrative details are drawn from this act. More than half of the provision of the constitutions are identically to this act of 1935. The third feature of the Indian Constitution is the mixture of rigidity and the flexibility. Constitutions are also classified into rigid and flexible. A rigid constitution is one that requires a special procedure for its amendments, as for example the American Constitution. A flexible constitution, on the other hand, is one that can be amended in the same manner as the ordinary laws are made. as for example, the British Constitution. The Constitution of India is neither rigid or nor flexible, but a synthesis of both. Some provisions can be amended by the special majority of the Parliament, like two-thirds majority of the member of each house present and voting, and a majority more than 50% of the total membership of each house. Some other provision can be amended by a special majority of the Parliament and with the ratification by half of the total state. At the same time, some provisions of the constitutions can be amended by a simple majority of the Parliament in the manner of ordinary legislative process. And the fourth feature of the government of the Indian Constitution is the parliamentary form of government. The Constitution of India has opted for the British parliamentary system of government rather than American presidential system of government. The parliamentary system is based on the principle of government, the cooperation and coordinations between the legislative and the executive organ, while the presidential system is based on the doctrine of separation of power between two organs. The parliamentary system is also known as the Westminster model of government, responsible government, and the cabinet government. The Constitution establishes the parliamentary system not only the center but also in the states. The feature of parliamentary government in India are presence of the nominal and real executives, majority party and rule, collectively responsibility of the executive to the legislature, membership of the minister in the legislature, leadership of prime minister or the chief minister, dissolution of the lower house. Even though the Indian parliamentary system is largely based on the British pattern, there are some fundamental differences between the two. For example, the Indian Parliament is not a sovereign body like the British Parliament. Further, the Indian state has an elected head, republic, while the British state has hereditary head, monarchy. In a parliamentary system, whether in India or a Britain, the role of the Prime Minister has become so significant and crucial that the political scientists like to call it a Prime Ministerial government. And fifth feature of the Constitution is a synthesis of parliamentary sovereignty and judicial supremacy. The doctrine of the sovereignty of Parliament is associated with the British Parliament, while the principle of judicial supremacy with that of the American Supreme Court. Just as the Indian parliamentary system different from the British system, the scope of judicial review power of the Supreme Court in India is narrower than that of what exists in US. This is because the American Constitution provides for due process of law against of procedure established by law, contained in Indian Constitution Article number 21. Therefore, the framers of the Indian Constitution have preferred a proper synthesis between the British principle of parliamentary sovereignty and the American principle of judicial supremacy. The Supreme Court, on one hand, can declare the parliamentary laws as unconstitutional through its power of judicial review, and the parliamentary, on the other hand, can amend the major portion of the Constitution through its constitute power. Sixth feature of the Indian Constitution is integrated and independent judiciary. The Indian Constitution establishes a judicial system that is integrated as well as independent. The Supreme Court stands at the top of integrated judicial system in the country. Below it, there are high courts at the state level. Under a high court, there is a hierarchy of subordinate courts, that is district courts and other lower courts. This single system of courts enforces both the central laws as well as the state laws, unlike in USA, where the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. The Supreme Court is a federal court the highest court of the appeal, the guarantor of the fundamental rights of the citizens, and the guardian of the Constitution. Hence, the Constitution has made various provisions to ensure its independence, security of tenure of the judges, fixed service condition for the judges, all the expenses of the Supreme Court, charges on the Consolidated Fund of India, prohibition on discussion on the conduct of judges in the legislature, ban on practices after retirement, power to punish for its contempt vested in the Supreme Court, separation of the judiciary from the executive, and so on. And the seventh feature of the Constitution is fundamental rights. Part 3rd of the Indian Constitution guarantees 6 fundamental rights to all its citizens. First is right to equality. It contains Article 14 to 18. Second is right to freedom. It contains Article 19 to 22. Third is right against exploitation. It contains Article 23 to 24. Fourth is right to freedom of religious. It contains Article 25 to 28. Fifth is cultural and educational rights, Article 29 to 30. And the last, right to constitutional remedies. It contains Article 32. The fundamental rights are meant for promoting the idea of political democracy. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. They are justiciable in the nature, that is, they are enforceable by the court for their violation, and they aggrieved person can directly go to the Supreme Court, which can issue the writs of habeas corpus, mandamus, prohibitions, certiorari, and quo warranto for the restoration of his or her rights. However, the fundamental rights are not absolute and subject to a reasonable restriction. Further, they are not sacrosanct and can be curtailed or repealed by the Parliamentary through a constitutional. They can also be suspended during the operation of a national emergency, except the rights guaranteed by Articles 20 and 21. The eighth feature of the Indian Constitution is directive principle of the state policy. According to Dr. B.R. Ambedkar, the directive principle of the state policy is a novel feature of the Indian Constitution. They are enumerated in Part 4th of the Constitution. They can be classified into 3 broad categories: socialist, Gandhian, and liberal intellectual. The principles are meant for promoting the idea of social and economic democracy. They seek to establish a welfare state in India. However, unlike the fundamental rights, the directive principles are not justiciable in nature. That is, they are not enforceable by the courts for their violation. At the Constitution itself declares these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Hence, they impose a moral obligation on the state authorities for their applications, but the real force sanctioned behind them is political, that is, public opinion. In the Minerva Mills case, 1980, the Supreme Court held the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. So, the ninth feature of the Indian Constitution is fundamental duties. The original Constitution did not provide for the fundamental duties of the citizens, and these were added during the operation of internal emergency 1975 to 77 by the 42nd Constitutional Amendment Act of 1976 on the recommendation of the Swaran Singh Committee. The 86th Constitutional Amendment Act of 2002 added one more fundamental duty. The Part 4th A of the Constitution, which consists of only one article, 51A, specifies the 11 fundamental duties to respect the constitution, national flag, national anthem, to protect the sovereignty, unity, integrity of the country, to promote the spirit of common brotherhood amongst all the people, to preserve the rich heritage of our composite culture, and so on. The fundamental duties serve as a reminder to citizens that while enjoying the right, they have also to quite conscious of duties they owe to their country, their society, and to their fellow citizens. However, like the directive principles, the duties are also non-justiciable. So, the 10th feature of the Indian Constitution is a secular state. The Constitution of India stands for a secular state, hence, it does not uphold any particular religion as the official religion of the Indian state. The following provision of the Constitution reveal the secular character of the Indian state. The term secular was added to the preamble of the Indian Constitution by the 42nd Constitutional Amendment Act of 1976. The preamble secures to all citizens of India liberty of belief, faith, and worship. The state shall not deny to any person equality before the law or the equal protection of the laws. Article 14. The state shall not discriminate against any citizens on the ground of religious. Article 15. Equality of the opportunity for all citizens in matter of public employment. Article 16. All persons are equally entitled to freedom of conscience and the rights to freely profess, practice, and propagate any religious. Article 25. Every religious denominations or any of its sections shall have been right to manage its religious affair. Article 26. No person shall be compelled to pay any taxes for the promotion of any a particular religion. Article 27. No religious instruction shall be provided in any educational institution maintained by the state. Article 28. So, 11th feature of the Indian Constitution is universal adult franchise. The Indian Constitutions adopt universal adult franchise as a basis of election to the Lok Sabha and the state legislative assemblies. Every citizen who is above than 18 years of age has a right to vote without any discrimination of caste, race, religion, sex, literacy, wealth, so on. The voting age was so reduced to 18 years from 21 years in 1989 by the 61st Constitutional Amendment Act of 1988. The introduction of universal adult franchise by the Constitution's makers was a bold experiment and highly remarkable in a view of vast size of the country, its huge population, high poverty, social inequality, and overwhelming illiteracy. Universal adult franchise makes democracy broad-based, enhances the self-respect and the prestige of the common people, uphold the principle of equality, enables minority to protect their interests, and open up new hopes and vistas for weaker section. So, the 12th feature of the Indian Constitution is a single citizenship. Indian Constitution provides a single citizenship to all citizens of the country. Through the Indian Constitution is federal and envisages a dual polity, central or states. It provides for only a single citizenship, that is the Indian citizenship. In countries like USA, on the other hand, each person is not only a citizen of USA but also a citizen of particular state to which he belongs. Thus, he owes allegiance to both and enjoys dual sets of rights, one conferred by the national government and another by the state government. In India, all citizens, irrespective of the state in which they are born or resides, enjoy the same political and civil rights of the citizenship all over the country, and no discrimination is made between them excepting in few cases like tribal areas and so on. Despite the constitution provision for a single citizenship and uniform rights for all the people, India has been witnessing the commonwealth riots, class conflicts, caste wars, linguistic clashes, and ethnic disputes. This means that the cherished goal of the constitution's makers to build an united and integrated Indian nation has not been fully realized. 14th feature of the Indian Constitution is emergency provision. The Indian constitutions contain elaborate emergency provision to enable the president to meet any extraordinary situation effectively. The rationality behind the incorporation of these provisions is to safeguard the sovereignty, unity, integrity, and the security of the country. The democratic political system and the constitution. The constitution envisages the three types of emergency: the national emergency on the ground of war or external aggression or armed rebellion, Article 352. Second is a state emergency, president's rule on the ground of failure constitution machinery in the states under Article 356 or failure to comply with the direction of the state of the center. And the third is financial emergency on the ground of threat to the financial stability or credit of India under Article 360. During an emergency, the central government become all powerful and the states goes into the total control of the center. It converts the federal structure into a unitary one without a formal amendment of the constitution, and this kind of transformation of during political from federal during normal times to unitary during emergency is a unique feature of the Indian constitution. Fifth feature